Well, welcome everyone. It's so nice to see so many folks here, and it is truly an honor to get to introduce our speaker today, the Honorable Jon Newman from the Second Circuit Court of Appeals. So Judge Newman's career is about as distinguished as they come. After graduating from the Yale Law School, Judge Newman went on to clerk for George Thomas Washington of the D.C. Circuit Court of Appeals, and then Chief Justice Earl Warren of the United States Supreme Court. He later served as the United States Attorney for the District of Connecticut before being appointed to the District Court in 1971. And I'm not going to say anything about ages here, but let's just say that he wasn't that much older than I am now when that happened, right? And I'm not that old. Okay. So he was then elevated to the Second Circuit only 8 years later and served as Chief Judge of that esteemed court from 1993 to 1997. Judge Newman is truly a judge's judge. He is a real leader among the federal bench. And so let me just say, just to make this a little bit more concrete, so if one could be class president of the judiciary, I think Judge Newman would win in a landslide. And quite recently, Judge Newman was actually awarded the Edward J. Debit Distinguished Service to Justice Award. That is truly an honor, right? It goes to an Article III judge who has, quote, achieved a distinguished career and made significant contribution to the administration of justice, the advancement of the rule of law, and the improvement of society as a whole. Judge Newman is also a scholar. He's written numerous articles and books about the judiciary and judicial administration, and he's also written on the hugely important topic that he will be discussing today, the federal sentencing guidelines. Judge Newman, it's so wonderful to have you here with us.
Thank you, Professor Levy. Well, thank you for permitting me to interrupt your lunch or share the time with you. First, let me say what a privilege it is to participate in this program that the law school offers to invite a judge to spend time with students and faculty of this great law school. I'm really quite privileged to do it and grateful for having been invited. I should first make a slight disclaimer in case you were lured here under false pretenses by the title of the lecture. There was a word missing. It now says federal sentencing, the good, the bad, and the awful. It was supposed to say federal sentencing guidelines. I don't think federal sentencing is awful, although it's not marvelous either. But my focus is the guidelines. Now, I don't know, we're early in the year, so I guess your knowledge of the guidelines goes from probably zero to middle to a lot. How many have taken a criminal law course that exposed you to the guidelines? Oh, a few. And how many know nothing about the guidelines? Okay, I'm going to talk to you. Let me start by saying a word about sentencing in general. Civilizations have been trying to figure out how to sentence those who violate laws for centuries, and no one has figured it out. There is the inevitable tension between trying to particularize a sentence to the precise offense and the precise offender characteristics, to be very, very fair to that individual. As opposed to that is the effort to avoid disparity, because the minute you particularize excessively, you end up with a wide range of sentences that seem very disparate, and indeed are disparate. Disparate regionally, racially, gender, all kinds of other things. The concern about disparity prompted a reform movement back in the 1970s. I'm going to just have a little lead up to this and then get to the guidelines themselves. But I think to put it in perspective, it's important to know how they came to be. In the 70s, a very distinguished federal judge named Marvin Frankel wrote a book called Law Without Order, essentially making the point that disparity was rampant through federal sentencing. It was also true in the state systems, but he was a federal judge and he was focused on federal sentencing. There were widespread regional and racial disparities around the country to an astonishing degree. And it occurred because, not that judges were willfully discriminating, but they were making a series of unstructured, random decisions focusing on the particular defendant in front of them. And they had no body of law to guide them as they made that decision. When I was a district judge and a defendant came before me for armed bank robbery, the maximum sentence was 25 years. I could give that person anything from 25 years to probation, 0 time. Unlike any other area of the law, there were no standards, there were no guidelines, there was no law to tell me where between 0 and 25 I ought to place that defendant. I always thought that was virtually a lawless system. I could ask colleagues, what do you generally do with an armed bank robber? I could ask the probation officer that prepared a pre-sentence report. I could get some help. But unlike any other substantive area of the law, if it was an antitrust case, I could read a lot of cases about antitrust law and get a sense of what I was supposed to do. I had no guidance when it came to sentencing. And the result was the kind of disparities I've talked about, and even disparities with respect to a specific offense. For example, if you take income tax evasion, about half the judges, the federal judges of the United States in the 1970s, were sending income tax evaders to prison, maybe 6 months, maybe a year, maybe 2 years. About half the judges were putting them all on probation. It just depends whether you got a judge who thought jail was appropriate for a tax evader or you didn't. So to Judge Frankel, that seemed like an outrageous system. So he wrote this book. And the book proposed that there be some form of guidance for sentencing judges throughout the federal system. The idea, which originated in that book, was that Congress should pass a law creating what became known as the Federal Sentencing Commission, which exists today. And the commission would publish a set of guidelines, not hard requirements, but guidelines that would guide judges as to what the appropriate sentence in any given case should be. That proposal led to the convening of a seminar, if I can mention it, the Yale Law School, another law school, a seminar that was run for a semester with Judge Frankel attended, I participated, and with students, and we fashioned a bill to implement the Sentencing Commission proposal. And in due course, that bill became the Sentencing Reform Act of 1984. Curious thing about that bill was the bill in the Senate was co-sponsored by Senator Ted Kennedy and Senator Strom Thurmond. Talk about an odd couple. They came at it from very different perspectives. Senator Kennedy wanted to lessen disparity. Senator Thurmond wanted to be sure people were put away for a long period of time. But they joined forces, and they both agreed that a sentencing commission, along the lines of the Frankel book and the Yale seminar proposal, would be a useful idea. So they had this bill, the Sentencing Reform Act, that called for the appointment of a 7-member commission, and it had some criteria as to what the guidelines should look like. Not too many, but a few requirements. And then we waited for a while for this process to unfold. And the first thing that happened is the president appointed 7 members of the commission. Well, as we looked at that, we were startled because we thought we would have a 7-member commission with, let's say, a governor or an ex-governor, a mayor, a prosecutor, a public defender, a probation officer, and perhaps one professor of penology or criminal law who would sort of bring the academic perspective. To our astonishment, the committee included, out of 7, 3 professors. Now, I don't want to be at the Duke Law School and castigate professors. That's not my objective. But I think 3 professors out of 7 on a sentencing commission was a little excessive. And I'll revert to that in a moment as I get to it. In any event, the commission went to work and after a year produced the first set of guidelines. Now I should backtrack a little and say what those of us who called for guidelines expected. We expected something that would look very close to what were then the parole guidelines. Parole was the law in 1984. Parole is not the law today. There's no federal parole. There's state parole, of course, but there's no federal parole. Federal parole, I should digress to say, was abolished because of the idea there should be truth in sentencing. That was the phrase. So if a guy got 20 years, but he got released at the 1/3 point after serving between 7 and 8 years, they thought the public was misled. So they said, well, we don't want parole. Parole had been a wonderful idea, some thought, to monitor prisoners and give them some incentive to behave in prison so they would be sure and get parole. But the idea was, no, it undermines confidence or undermines truth in sentencing, so we should abolish parole. And they did abolish parole. But the Parole Commission, while it existed, had issued a set of guidelines for the use of parole hearing officers to determine when in the course of a 20 or 25-year sentence the prisoner should be released. He was eligible at the 1/3 point, but he didn't have to be paroled. So it might be the 1/3 point, the 1/2 point, the 2/3 point, or whatever. And parole decisions were different all over the country. So the Parole Commission said, let's bring a little standardization to this. Let's have guidelines. So they constructed a table. And the table had some offense severity categories. It's only 6 of them. Small severity, medium severity, middle severity, high severity, just 6 categories. And then across the top, prior record. Very little record, some record, middle record, a lot of record. And it was a grid, if you can visualize that. And at the intersection of your offense severity and your prior record severity was a range of months. And the parole officer would look at that and say, well, this fellow committed a medium level offense and he's got a slight prior record. That means that as a general rule, he ought to get parole at whatever was set in that range. Maybe, let's say if he got a 4-year sentence, maybe he should get parole at 18 months or 12 months, let's say. It was a 3-page document. And those of us who were for the Kennedy-Thurman bill said, good, it'll be a sentencing commission, and they've got a 3-page model to use, and they'll come out with something similar to that. We were wrong. Be careful what you wish for. The first draft came out 250 pages. Not 3 pages, 250. This utterly complicated system for trying to figure out with precision what federal sentencing judges should do. Some of us were aghast, testified against it, said it was way too complicated. Commission went back, revised it, made it just a little bit simpler. Several of us said it's still terrible. Commission went back, had a 3rd version, made it worse. Came out with 300 pages. That was the first version. Since then, they have been amending it probably 600 or 700 times. The guideline booklet is now about 500 pages. And it went into effect in 1987. It was tested in the Supreme Court. Many judges thought it was unconstitutional. I think about 200 judges around the country said it was unconstitutional. I sort of suspect they didn't much like the idea of having their discretion limited. In any event, many of them said it was unconstitutional. Went to Supreme Court, a case called Mistretta. Supreme Court said, no, it is constitutional. So that launched the era of guideline sentencing with the blessing of the Supreme Court. The guidelines, and I'll come to some of the specifics in a second, told the sentencing judge to take a look at the offense severity, but instead of having 6 categories, there are now 43 levels of offense severity. And then across the top, about 6 levels, 6 lines of prior record severity. That stayed the same. but the table is 43. So if you take the guideline book, it's heavy, carried around, and look at the back, there's the sentencing table. And it shows you that for the 43 levels of offense severity and the 6 categories of prior record, there's a sentencing range, usually a range of about 6 months, sometimes a little more at the high end. And the judge was supposed to find that appropriate box and use that, with one exception, that the original guidelines said, if the judge thinks that for certain reasons, not any reason, but for certain reasons, the judge thought this case either merited a sentence above the prescribed range or below the prescribed range, the judge could make what was called a departure. In the beginning, judges were somewhat reluctant to make departures. They found it, I think it's fair to say, comforting to use the guideline table. Instead of having to think, where from 0 to 25 do I sentence that bank robber, I simply look it up. And I see, oh, bank robbery is at level whatever, 30, I'm just using that as an example, and this guy has a number 2 prior record. So that starts me off. Then I make some adjustments. I look to see, did he injure anybody? If he injured anybody, the offense severity goes up. Well, it doesn't just go up for injury, it goes up so much for slight injury and a little more for heavy injury. And if the injury is between slight and heavy, it goes up in between. Brilliant, brilliant precision. But you could make those departures. In the first few years, departures were made at about 11% of all sentences. But that means that about 89% were precisely in the guideline range. And that went on for many, many years until about 2005, when the Supreme Court made another major decision in the area. There are lots of others. I'm not going to take the time to do that. Your criminal law course can tell you about the others. But the next major decision was United States against Booker in 2005. And that came about in, I think, a curious way. The court had decided a case called Apprendi, which criminal law courses know and the others don't, but the criminal law course people will tell the other people what it was about. It was essentially a case that said, look, sentencing judges can take a lot of things into account besides the offense of conviction. He's in there for armed robbery, or maybe he's just in there for robbing a convenience store. But the sentencing judge says, yeah, but he's done all these other things too. And these other things, they didn't go to the jury, and they only have to be proved to the judge's satisfaction by a preponderance of the evidence, not beyond a reasonable doubt. Well, the court in Apprendi said, well, wait a minute now. We can't have people sentenced on findings that aren't beyond a reasonable doubt. That's not right. So they struck down some sentencing judge fact-finding. Then judges using the sentencing guidelines, according to the Supreme Court, said, wait a minute. The guidelines are based on counting all those other things. So if the guidelines force judges to count things that haven't been found by a jury, you're violating Apprendi. And the Supreme Court said, that's right. Now, how did they solve it? Brilliant. They said, the guidelines are no longer mandatory. You don't have to use them. They're advisory. But they said, and this was critical, you do have to start with the guidelines if you're a sentencing judge. You can't just look at the defendant and say, I think he should get 8 years for armed bank robbery. No, no, no. You must calculate the guideline range for that offender with those offense characteristics. Then, if you want to do it differently, you're not as limited as you were to a departure. You can simply say, I'm not going to use a guideline sentence. And several judges took that flexibility and gave non-guideline sentences. But it varies tremendously around the country. In some districts or with some judges, there are some judges who use their guideline sentence 90% of the time. There are others who use it about 30, 40% of the time. I think the nationwide average is in the 50s, but it varies a lot from district to district, varies a lot from judge to judge, varies from case to case, even with the same judge. So that's the framework of the guideline system. Now, before I trash the guidelines, I want to say what's good about them. I want to be fair to the commission. There are some good things. The first thing is, and this is very important, the guidelines have somewhat reduced sentence disparity. It's a hard thing to measure because there's no agreed upon measurement of how you do. I guess the statisticians have some algorithms or something, but essentially it's hard to quantify disparity. But if you look at it in gross terms, you can see that the amount of disparity is less since the guidelines than it was before. And I think that's a very good thing. Regional disparity is down, racial disparity is down. Not eliminated by any means. And you will still pick up a newspaper or watch on TV or radio, wherever you get your news. Two people who seem to have done virtually the same thing, getting very different sentences. That still goes on in the United States today. But it has improved under the guidelines. Another good thing about the guidelines is this. The commission had to make a very interesting choice in the beginning. What is it you're going to impose the sentence for? Now you may say, well, that's a silly question. You're going to impose the sentence for what he did, right? Well, the choice was this. Do you use the offense of conviction only? He was convicted of embezzling. But he also threatened the teller with a knife. But he wasn't convicted of that. So do you just use the offense of conviction? Or do you, that would be called charge offense sentencing. The other extreme was real offense sentencing, the way a sentencing judge used to do it. The sentencing judge used to get a pre-sentence report and say, yes, he did crime X. But in the sentence report was everything else he had done bad that day or the week before. He'd also threatened his wife. He'd also cheated on his taxes. He'd also done all kinds of other things. The judge, oh, well, you're not just a person who robbed a convenience store. You're a fellow who did 6 other bad things. I'm going to sentence you to all those things, for all those things, up to the maximum. You couldn't go beyond the maximum for that offense. But that was called real offense sentencing. Commission had a choice between charge offense sentencing, real offense sentencing. And they said, we're not going to do either. We're going to have what we call modified real offense sentencing. The judge is entitled to take into account at sentencing everything the defendant did that is relevant to the offense. So if he went into a bank and committed robbery, and in that robbery he brandished a weapon, well, that's relevant to the offense, so that counts extra. But if he cheated on his income tax, that's just not relevant to the offense. You've got to have a separate case for that. So it had to be relevant to the offense. And then what if he did it with others? And this would be a problem, particularly in drug cases. What if he moved a small quantity of cocaine, but his co-conspirators moved kilograms worth of cocaine? Is he responsible for that too? You had to make a choice. So the commission says, and the foreseeable acts of his co-conspirators in furtherance of his crime. So they compromised, and I think that was a sensible compromise. It was an interesting one, and I give them credit for making it. Third thing I want to give them credit for is dealing with the problem of consecutive sentences. Sentencing judges always have a choice when someone is convicted of more than one count, whether to run the sentences concurrently or to stack them and run them consecutively. Just to give you one of my favorite examples, I had a case where a fellow committed a crime, this is in the appellate court, for which the maximum sentence was 2 years. There were 11 counts. Now, if you're ahead of me and your math is good, you will anticipate. The sentence was 22 years. He stacked all 11 counts on top of each other to take a 2-year crime and make it into a 22-year sentence. The commission said, you know, we don't think that's a very good idea. So we are going to require, under the guidelines, that with few exceptions, sentences are going to have to be concurrent. And the way they did that was to say, first you figure out what the recommended sentence under the guideline table is. Let's say it's 8 years. Then you take the statutes that the fellow has violated. And even if you could stack them and get to 20 years, can't do that. You got to go only up to the 8 of the guidelines, unless you want to give a non-guideline sentence, and then you can give him 10, 12, 14 years. But it was a presumption that current sentences were to be used and not have wide-ranging consecutiveness. I think that was a great step forward for fairness, frankly. Okay, now the bad. I think the worst thing about the guidelines is their unbelievable complexity. The idea that there would be this 350-page book, now 500 pages, that judges would use. And they do it. I mean, you know, there's a former judge sitting in the back here who has done it, and I've done it, and we've lived through it. They're incredibly complex. They don't need to be so complex. The federal system is not the only system with guidelines. States have guidelines. I don't know if North Carolina has it. I don't think so. But for example, Pennsylvania has a guideline system. Minnesota has one. The state of Washington has one. There are about 10 or 12 around the country. They are very good systems. They are not complicated. They are flexible. They give judges a good bit of leeway. But they do ease disparity. They cut down on disparity. They're very sensible. Why on earth the federal sentencing system didn't follow the model of good states, I don't know. Well, I do know. It was because of those 3 professors. We know that, as a matter of fact. One of them particularly, Paul Robinson. Paul Robinson had a theory that is unknown to sentencing law anywhere in the world. His theory was that for every increment of wrongdoing, there must be an increment of punishment. I call it the theory of incremental immorality. Now, what did he mean by that? He meant that if you go into a convenience store and you go to the till and you take $5,000, then you get level X. But if you go into a convenience store and there's 10,000, you get level Y, 6 months more. Now, as I've said to the commission and when I've testified, no criminal wakes up in the morning and says, I feel like committing $5,000 worth of criminality today. He probably distinguishes between going into a bank with a gun where it's dangerous and the guard might shoot him, and a convenience store where the chances are the proprietor isn't armed and that there isn't that much money. He may make that judgment. So I have no problem saying bank robbery deserves more punishment than convenience store. But once he goes into the convenience store, as I've said to the commission, he takes what's there. And it shouldn't get more punishment because that day there was 10,000 rather than 5,000. Or to take it into other areas. Let's say it's a postal inspector working a mail fraud case. And this is somebody who sends out fraudulent inducements to the public. And he runs this scam for a couple of months. And then over in the next state, another scammer, very similar, runs it for 4 months. And the difference is the first postal inspector has got a lot of cases. So after 2 months, he puts a stop to it, arrests the guy, and he's only got about 8 examples of fraudulent mailings. The other postal inspector got a light caseload, so he lets it go for 4 months. Now he's got 38 examples. And the total volume of dollars involved is a lot greater. So if you're going to have it run with a system of incremental immorality, the second fellow is going to get a much higher sentence than the first guy. But the only difference is that one had a postal inspector who had time on his hands and the other didn't, which really doesn't seem to me like a reason for escalating the punishment. They both did mail fraud. Or let's say it's drugs. One fellow, two fellows, they're both selling drugs. And there's an informant, typically. So again, in one case, the informant strings him along for 3 days, and he sells 300 grams of coke. And the other informant strings him along for 3 weeks, and he buys from him 1.5 kilos. They're both selling drugs. And the only difference is how long the case was allowed to run so that the quantity could go up. To me, it makes absolutely no sense to critically affect the sentence just by the time the investigators ran the investigation. Made no sense at all. Now, what did the commission do? The commission said, well, led by Paul Robinson, there are 2 things we can count precisely: money and drugs. We can count how much money was in the crime, and we can count the weight of the drugs that were in the crime. And as I have said on other occasions, the thing bean counters do, they count beans. They count what's countable. So you could count money, you could count drugs, but if you looked at something as intangible as role in the offense, how do you quantify that? So the commission made a, I think, horrendous mistake. They said, we know how to count money. We know how to count drug quantity. So we will construct a table. And the first table had 21 levels of money with a different range of sentencing at each level. And we will have, I think it's 36 levels of drug quantity and a different sentence for each one of those. And then they said, of course, role in the offense, oh, that's important, isn't it? So after you get finished figuring out the sentencing range based on the dollars or based on the drug quantity, if he had a major role in the offense, oh, you add 3 levels. If he had a minor role in the offense, you subtract 2 levels. Well, you've already up to level 38, but you go down 2 levels because he was a mule. So a mule crosses the border. He works for a big gang. The gang handles hundreds of kilos, but this is a mule. Or it's a girlfriend, and the major rig operator says to her, gee, tonight my car doesn't work. Would you drive me to the meeting? You know I'm in the business, but I'm not involving you. Just drive me to the meeting, will you? She says, of course. She's now a conspirator in a drug offense that involves multi-kilos. So she's up at level 38. Even though, what did she do? She drove him once to the meeting. By giving drug quantity and monetary amount primacy in the calculation of the offense, and role in the offense, the minor role, they did it just backwards. It's a classic example of letting the tail wag the dog. And they did it simply because it's easy to count quantity, it's easy to count dollars, and it's hard to figure out how to quantify role in the offense. Well, it's not hard to assess role in the offense. You've got district judges who are pretty sensible men and women around the country, and they know the difference between a kingpin and a mule. And all you had to say is, if he's a kingpin, go up 10 levels, go up 20 levels. And if he's a mule, start at the bottom. And they could have done that. And then made a slight adjustment for dollars and a slight adjustment for drug quantity, but they did it exactly the opposite. Absolutely crazy. They then ventured into another extreme. The way they started with their guidelines was this. They looked at 10,000 cases around the country to see what factors judges in fact were using to adjust sentences up or down, mostly up. So they looked at these 10,000 cases and they noticed interesting things. They noticed if there was a gun in the offense, the sentence was higher than if it wasn't a gun in the offense. They noticed if somebody was threatened with injury, the sentence was higher. Or take an area that gets litigated a lot, child pornography. The fellow sits at his computer and he receives images of child pornography either from a friend abroad, or not a friend, just a commercial purveyor of pornography abroad, or for a friend who also likes to look at pornography. So they set an offense level for viewing pornography, child pornography. Then they said, well, now, of course, in some cases, if he uses a computer, he doesn't just look at the photograph. If he looks at the computer, we're going to add 2 levels. Then they said, well, in some cases, the offense looks like he's sharing the photos. Add 2 levels for that. Then they said, sometimes it looks like a sophisticated operation. Add 2 levels for that. Well, I have no doubt that in certain cases, there was a slightly higher offense for each of those factors. But what the commission did is said, you add each factor, even though all those factors were almost always in the same case. So you started with, let's say, level 10, I'm just taking an example, and then you said 2 for sharing, 2 for computer, 2 for sophistication, and pretty soon you had doubled the offense for factors that were true in every case. That was crazy. And when I first had that case, and this was before the guidelines became advisory, I at least said that if a judge is stacking those add-ons, the very fact of stacking is itself a reason for departing from the guideline sentence. I don't think the commission much liked my doing that, but, and then some judges took advantage of it. But that's what they were doing. Another thing they did that was odd, there are, as you know, mandatory minimum sentences. That's a whole problem unto itself. We can talk about that later if you want. But in any event, let's just say there are. And there are mandatory minimums of 10 years, some 20. In the drug area primarily, guns also, but mostly drugs. So what did the commission do? They had to come up with a guideline range for drug offenses. So they said, well, for this quantity, the Congress says it's a mandatory 10 year. So then in the guidelines, we will start with that, and we will build our guideline system on top of it. Well, as I said to them, that was a huge mistake. I know the mandatory system is there. On the other hand, you're the expert commission. You were created to tell us what you think is the right sentence for certain offense conduct. So you should have set the guideline for drug quantities where you thought it should be. If the mandatory minimum bumps it up, okay, that's Congress's problem. But they didn't do it that way. They said, we will start wherever Congress starts, and then we'll go even higher. I think that was a colossal mistake. Another mistake, there is in law, it has been in sentencing law forever, that if the fellow cooperates with the government, he gets a discount for cooperation. And there's a specific guideline, 5K1. You get a departure for cooperating with the government. So far, so good. What did the commission do? They said, you get a discount for cooperating with the government if the prosecutor makes a motion for a lower sentence. And if the prosecutor doesn't make that motion, you don't get the discount. We had an interesting session many years ago. The commission invited a lot of federal judges to come. All the commission was there, and there were about, probably 150 judges in the room. And I said to one of the commissioners, why did you put in this requirement of a government motion? That gives the prosecutor a whip hand. And he uses it. I had one unbelievable case where the guy said, Your Honor, we didn't get a discount because the government wouldn't make the motion, even though my client gave them 6 other people involved in the offense. I said, why didn't you get the motion? Well, they wanted the 7th, and the 7th was his sister, and he wasn't going to give up his sister. But he did give up 6 other people, but he didn't get the cooperation motion from the government. So I said to the commission, why did you require the trigger of a government motion? And a commissioner said to me, well, we didn't invent that. It was always that way. Now, this was a room of about 150 district judges, at least half of whom had been U.S. attorney, you should have heard the gasps of dismay. Because we all knew that had not been the way it was. The commission just was wrong in understanding what had happened. There was never a requirement of a government motion. At sentencing, the prosecutor would get up and say to the court either, yes, he has cooperated or he hasn't. And the defense lawyer would get up and say, yes, he has cooperated. They'd make their presentations and the judge would hear them out. No more. There has to be a government motion to permit a cooperation discount. That's crazy. I'm going to have some time for questions, but I've got to mention at least one more of these. The commission, in its wisdom, said that when you look to see what he has done in deciding what the punishment should be, of course you look to see what he's been convicted of. And of course you look to see what other conduct is relevant to the offense. But then you look to see the charge on which he was acquitted. And that counts too. Now, it seems a little bizarre, and it's not totally bizarre, because even before the guidelines, if a person was charged with crime A, convicted of count A, and came before the judge could look at other things. He hadn't been acquitted of the other things. He hadn't even been charged with the other things, but they were in there. But now you had this phenomenon that the government had gone to the jury and tried to convict him of another crime, and the jury had said, no, we don't find him guilty beyond a reasonable doubt of that. But at sentencing, the things you've done wrong need only be proven to the judge's satisfaction by a preponderance of the evidence, which all you tort students know, and all your civil litigators know, is just a little more than 50-50. But isn't it odd to take a fellow and say, yes, you've been actually acquitted of this conduct by a jury, but you're going to be punished? Let me give you one wonderful example we had in our court. Fellow was convicted of a crime that carried a 2-year maximum. There was another crime that made him eligible. Well, there were several of them, so it could be run up higher. But the thing he had really done was a 2-year crime. He was acquitted of a 20-year crime. But because there were so many 2-year crimes, the judge looked at it and said, yeah, well, he was acquitted of the 20-year crime, but the guidelines say I can use that. Gave him 20 years. That's still the law today. And it's a little hard to explain to that people how you get acquitted of something, but you still get punished for it. Very, very odd. There are others, but I don't want to take the time. I want to come back to complexity. The idea that sentencing judges have to go through this utterly complicated task of figuring out every little adjustment, every dollar increment. I once had a tax case on appeal, and I wrote a 30-page opinion to figure out, was the tax loss something like $240,000 or was it $280,000? Something that would have been settled in the civil side of the case, and probably settled. It would have never even been tried out before the commissioner or before the tax. It would have been settled. But because the sentencing changed, depending on whether it was $240,000, $280,000, I had to write a whole opinion going through tax loss, all kinds of complicated stuff, in order to figure out the right sentence. That's crazy. It doesn't need to be that complicated. The loss table doesn't have to have, well, they did change it. I got to give them credit. It was 21 levels. I testified at another hearing. I said, you can shorten it. They shortened it from 21 to 16. I said, you only need 4. There should be a small quantity of money, a medium quantity, a large quantity, and a very large quantity. That's all you need to tell a judge how much money is involved in the case. That's all you need. They've never done it. I don't think they will. They don't change it for drugs. The drug quantity table is still a massive thing, and the adjustments for role in the offense is still relatively trivial. So it has complexity It burdens district judges. It also, I think, pretty much inhibits them from not using the guidelines, because a lot of judges who have never known anything, Judge Levy and I, who knew the pre-guideline world, we knew about that. But most judges, we're sort of the antiques of the sentencing era, if I may put it that way. Most people who have become judges in the last 20 years have never sentenced pre-guideline. They only know the guidelines. So when the probation officer comes in and says, Judge, we've done the calculation, and the guideline range is 36 to 42 months. A lot of judges say, thank you very much, that's very helpful. Says to the defense lawyer, you have any objection to the guideline calculation? The defense lawyer typically says, no, it looks all right to me. Okay, 36 to 42, I'll be nice, I'll give you 36 months, bottom of the guideline range. Doesn't even think about not using the guidelines. Some of them do, but many of them do not. So we have this incredibly complex system that is still being used literally by many, many federal sentencing judges. The result is a lot of sentences that are just too high. There is no parole system to alleviate. Theoretically, there's a pardon system, but good luck on that. That's not going to help. So we have this odd system. And what it has done worldwide is very discouraging. I go abroad, and we talk about sentencing. I say, do you have a guideline system? Oh, they said, we're not going to have a guideline system. Those federal guidelines of yours are terrible. They have given guidelines a bad name all over the world. And I say, don't look at the federal guidelines. Look at Minnesota's guidelines. Look at Pennsylvania's guidelines. They're very good if you want to think about guideline sentencing. But they don't do that. The federal model is the model they know about, and they see it's ridiculous because it's way too complicated, and so they don't use it. I don't know about other states. I don't know if North Carolina has given thought to guideline sentencing. If they do, I hope they follow the model of other states instead of the federal, because the federal is too complicated and has this perverse dog-wagging-the-tail phenomenon that drug quantity and monetary amounts drive the system, and role in the offense is trivial, and it should be just the other way around. So I hope I've persuaded you that there are some bad features and that it could be improved, and maybe someday it will. The commissioners change seats. They're term limited, and there's turnover in the commission. But in the years of its existence since 1984, there has been no effort whatsoever to simplify, and no effort whatsoever to depart from these fundamental premises that every increment of punishment deserves an increment of crime or wrongdoing deserves an increment of punishment. That is still the fundamental premise of the guidelines, and it just makes no sense. No penological system in the world uses it. It's just unheard of. But here it is in federal sentencing. So that's why I think they're not very good. I think they've helped a little bit, as I've tried to indicate, but they could be so much better if only the commission would sit down and reassess what they've done. Interestingly enough, they said they would do this. If you look at the guideline manual, it says in the beginning, this is an evolutionary process. This is only the first cut. It's evolutionary. Well, as I've said to them many times, let the evolution begin, because it hasn't. And I hope they will. I hope there will be commissioners in the future. Maybe some of you, as you become practitioners, judges, commission members, will think about these things and say, you know, we could do better. And I hope you will. So if you have questions, fire away. Thank you. Yes?
I know in North Carolina, we also shifted from a model of indeterminate sentencing to determinate sentencing.
Mm-hmm.
We have something called the Structured Sentencing Act in place right now, which gives a minimum and a maximum for pretty much every crime, and you're not allowed to deviate from that. You're not allowed to go below that. And we also abolished parole when we made that shift.
Mm-hmm.
Do you think both on the federal level, and I think there's something like 15 states that don't have parole right now, do you think parole should be brought back and that we should shift back towards indeterminate sentencing, where through good behavior and participating in programs in prison that you can earn good time?
Yeah. I guess my answer will depend on whether there's a good guideline system in place or a crazy one. Under the present guideline system, I would just as soon go back to parole. I think the flexibility it offers makes sense. I think the chance for those running prisons to have the parole possibility is very important to maintain discipline in prison. If you had a very sensible guideline system, then I can see not having parole. There is a truth in sentencing argument. Although, I should point out, the Commission and this Congress totally misperceived the public reaction. They thought that by abolishing parole, the public would understand that if they read that the fellow got a 15-year sentence, that meant 15 years. Oh, I should add, less time off for good behavior. There's a 1/7 reduction, 4 days a month. But they would understand 15 years meant essentially 15 years. Well, they were wrong. Why were they wrong? They were wrong because federal sentencing is about 2% of all sentencing. Most sentencing is state sentencing. So every day in the paper or on the television, they read, this fellow got 15 years from the state of North Carolina or the state of New York, and he got out after 6 years on parole. They hear that all the time. The public doesn't have the slightest understanding that there's no such thing as federal parole. There's only one group that understands there's no such thing as federal parole. Those are federal prisoners. They understand it, and I guess their lawyers do. But the public doesn't understand it because they read about parole release decisions all the time. So the truth in sentencing rationale, which drove the abolition of federal parole, was a myth. So I would bring it back, certainly to avoid a complicated guideline system. But under a sensible guideline system, particularly with the Booker decision and the ability to have a non-guideline sentence, I think that would be a good combination. It's a tough choice for states to make, and no answer is perfect. There are pluses and minuses, like most hard policy choices, which you do. So that's a complicated, evasive answer. Yes, in the back.
A lot of counties are adopting these black box software programs that provide risk scores to people, and in some ways they're maybe taking on some of the role that sentencing guidelines used to. How do you see that system? How do you see the role of the government in propagating that system at the federal level? And is that helpful? Is that dangerous? Do you have any thoughts on that generally?
Well, I got to confess I don't know enough about it to have a really sensible. When you talk about risk assessment, I guess they're going to do what the early parole guidelines did and what the sentencing guidelines try to do, to try to identify those characteristics that predict recidivism. It's a very hard thing to do. If you say it's in a black box, I'm not surprised, because if you look inside, I don't think you're going to see much. But if there is a black box that will tell people how to really measure the risk of recidivism, that's fine. I guess there are some characteristics that correlate with high recidivism or low recidivism. I don't think, again, out of ignorance, I'd have very much confidence, because I think it's a very chancy thing. Don't think we know enough about human behavior to know who is going to commit another crime and who isn't. We probably have some situations where there's a high likelihood of recidivism, but can we have a very low rate and say, oh yeah, this fellow just not going to commit another crime? We're not going to be that confident. The surest way, most of the data I've seen to assure that the person is not going to commit another crime is to have him grow older. Recidivism declines at old age. I mean, I haven't committed a crime in the last several years. But you've got a lot of people in prison today in their 20s and 30s, and many of them are serving outrageous times. They're serving 30-year sentences, 40-year sentences. The whole sentencing structure, I didn't really talk about severity in general, but the people who talk about the sociological problems of the inner cities, it's all about drug sentencing. There are no fathers in these families. These children are growing up without fathers because the father's doing 30 years. That's crazy. Now, I'm not saying legalize drugs. That's a whole different issue. But give him 2 years. Now, if he does it again, then give him 10, 20. But don't give a first offender 30 years. We're doing that in this country today. We're the only country in the world that does it. It's crazy. And it's having a terrible adverse impact on the sociology of the inner city. And then we wonder why. Well, that's the reason why. So I'm sort of evading your question because I just don't know enough about it. I don't know how good their risk assessment is. I'd like to find out more. Is there data that correlates with their prediction and then what happened? I mean, we have enough experience to make longitudinal studies and see how good the risk assessment is. If it's really good, wonderful. I got to admit, I'm skeptical. Yeah. Yes.
Would you say that there's more flexibility within the guidelines for prosecutors to manipulate the numbers in order to negotiate a plea than there actually is for judges to use their discretion?
I would say well, first let me compare the opportunities for prosecutors before the guidelines and after. I don't think the prosecutors benefited much by that. Because since this guideline calculation is supposed to be what they call modified real offense, it's what he really did. If the prosecutor takes the offense conduct and can figure out that it violates 3 statutes and say, well, count 1 is this statute, count 2 is this, count 3 is this, they're just variations on the theme. The guidelines kind of meet him on that and say, no. The guideline sentence is based on what he really did, not the number of counts you can divide. Where the prosecutor has the whip hand is on mandatory minimums. He says, particularly in the drug area, he says to the defendant, look, if you go to trial, I charge you with the 20-year mandatory minimum. If you plead, I don't charge you with the mandatory minimum, and you'll probably get 5 years. The state prosecutors do it too. That's another game that's played in this country. The state prosecutor has a fellow who is thinking of, should he go to trial? Should he plead guilty? The state prosecutor says, look, Charlie, you don't plead guilty. I walk you across the street to the feds, and they charge you with a 20-year mandatory minimum. So it's just as if the states had mandatory minimums, because all drug offenses can be either state or federal crimes. I mean, the federalism lines are non-existent in the drug area. So prosecutor manipulation can happen with mandatory minimums. I don't think it happens so much with multiplication of charges. Now, you ask, compared to the prosecutor with the judge has no option with respect to mandatory minimums. He's just not in that business. So to the extent there's a whip hand, it is in the hands of the prosecutor in picking the mandatory minimum charging decision. If that's off the table, then the judge has a good bit of leeway. He doesn't have the cooperation leeway that he ought to have, because that requires, as I said, the prosecutor's motion. It's outrageous. No reason whatsoever for a prosecutor to be able to withhold a cooperation discount. But the judge has a good bit of leeway, at least after Booker. He does not have to give a guideline sentence. Many of them do not. So on balance, there's the opportunity for judges not to be hemmed in by the guidelines. Unfortunately, many of them don't take advantage of that opportunity.
I think we have time for just one more question.
Whatever you say. Yes?
On the subject of plea bargains, that's obviously like every other area of criminal law where these sentencing guidelines have the most effect. How would you respond to the argument that a lot of the issues come to play in the minority of cases that go to trial anyway and then go to sentencing versus clean and then taking the sentencing hearing? And that it might just be the fact that those are the oddity cases that go to trial anyway, not that the guidelines are flawed.
Well, first, you're right. Very few cases go to trial, percentage-wise. Very small percent. And that's the percent of pleas went up slightly with the guidelines because it was more predictable what the guideline sentence would be. I don't know in the end if sentencing mattered. Well, sentencing varies. There is a precise numerical discount for pleading guilty. You either get a 2-level drop or a 3-level drop in this elaborate 43-level table of defense. So that's quantifiable. And they will say that to the defendant. If you plead guilty, you're going to get a 2-level discount, or if you're very nice, a 3-level discount. That happens. And if you get a cooperation agreement, and the government moves for cooperation discount, then you can, the guideline could be cut in half or 2/3, good, tremendous. Now, I don't know quite that answers your question, though. I don't think, did it? You look a little perplexed.
Kind of.
Does it? Okay, good, all right, fine.
Well, thank you
Enhance?
so much, Judge. This was wonderful. That's
Okay.
all.
Thank you.